Because there's just sometimes I hear in court that it should have stayed your hand, that when I filed this application, you shouldn't have taken any further action. But thank you very much for joining us. Good morning.
Good morning, sir.
I hope you're well.
I'm very well. Thank you.
I'm wondering if this morning you listened to the Member of Parliament for that.
I just listened in while I was driving.
Okay.
And I think I joined in the middle of the conversation.
Their view is that even though he had the constitutional right to do so, the clerk shouldn't have written that letter or send that corresponding to Parliament declaring the seats in KPANDAI vacant, because they filed a stay of execution. They've also filed a process at the Supreme Court. Do they have a case?
I'm glad that the Member of Parliament for Oda at least recognized that the clerk was exercising his constitutional mandate. I'm here to find any pointer in his submission to the effect that the circumstances named by him, namely that there was a pending motion for a stay of execution at the High Court and an action for judicial review, namely a certiorari application pending before the Supreme Court, are matters that will serve as a fetter on the powers of the Clerk of Parliament from exercising the functions or duties imposed by Article 1125 of the Constitution. In particular, Article 112 clause 5 provides that whenever a vacancy in Parliament occurs, the clerk to Parliament shall notify the EC, that's the Electoral Commission, within 7 days after the vacancy had occurred. And a by-election shall be held within 30 days after the vacancy occurred. I recall that Right Honorable Speaker, a little while ago, read a very erudite ruling when initially I think a member of the majority either moved a motion or made a request that the member for KPANDAI be prevented from participating in parliamentary business. The Speaker was right to indicate clearly in his ruling that by law there is an automatic stay of execution of any judgment that is executable. The 7-day automatic stay is imposed by law and not by a court order. And therefore, the Speaker took this into account and noting clearly that there being that statutory injunction, the member was automatically protected and could participate in the business of the House. And if I heard the Right Honorable Speaker clearly, he indicated the time limit within which this statutory stay will elapse. And that time clearly was indicated to be up to the 1st of December, if I'm right.
Yes, you're correct.
Yes, so I noted that the letter of the clerk to the EC was written after the 1st of December, if that is also right.
That's also accurate.
Yes, so I think that the clerk had no fetter at all to the exercise of that constitutional mandate in Article 1125.
But they say they filed a stay of execution. It was served on Parliament. The clerk should have a copy. That they believe should have prevented the clerk from writing that letter until that stay of execution. At least that stay of execution is heard, and the Supreme Court hearing is only on the 16th, so the clerk could have waited.
That is why I indicated earlier that I would have wished to hear from the submission of the honorable member of order that there is anything expressly or impliedly provided for in Article 1125, such as the circumstances mentioned by him, that could serve as a factor on the powers of the speaker, the clerk, so to act.
But he also points out that at least Parliament owes it a duty to respect the rule of law and not to, sometimes when these decisions are made, it makes it difficult for a court to stay something that has already happened.
No, this letter doesn't prevent the court from proceeding. My understanding is that the motion for stay, I don't know whether the motion for stay has been heard.
I'm not so sure.
I don't know the return date on that motion, and I'm only hearing about the motion pending before the Supreme Court that comes off sometime next week on the 16th, if that is also correct.
Yes, 16th, yeah.
Obviously, the Electoral Commission will not have conducted a by-election before the hearing of these two motions.
So, as far as you're concerned, the clerk did nothing wrong?
Not at all.
Didn't act illegally, prejudicially, or any of those?
The clerk's hand cannot be tied by any matter that the constitutional provision or any other law anticipates.
Having said that, then I want you, what do you make of the approach they chose yesterday, the minority?
In fact, I didn't even know about it until I'm hearing now, because as usual, I've been very busy, so I never followed developments in Parliament. It's only this morning that I was monitoring to find out that there was, I don't know whether it was a walkout or a protest.
It was not actually, they stayed in Parliament throughout. Were shouting on top of their noises. At one point, they moved from their sitting place towards that of the majority to try to prevent the majority from taking any further actions. And sat whilst the majority passed estimates. All they did was to continue shouting whilst they were being blocked away by the marshals.
Oh, I heard the honorable member for order again a little while ago, rationalizing why they did what they did. And you asked whether it was an act of desperation. He said, well, the circumstances were obvious to make anyone desperate. As to whether that step they took achieved their aim, well, I don't know. Because I heard the honorable member saying that the majority leader and leader of the House ought to have known or elected the important business that was pending in the House to their overzealous interest in having the KPANDAI member out of the House. But I can also say the same statement of the honorable member of order the other way. So the minority found the presence of, or the, what do you call it, non-inclusion or exclusion of the member of PANDAI, just one member, to be so important that the rest of them, 80-something members, will not participate in the third business of the house if it was so important. I do not understand what exactly.
He said they do not have a lot. Their numbers are small, and one seat is important to them.
The point I'm trying to make is that what difference will one member, that's a member, or the honorable member of PANDAI, what difference would it make if he were to be present in the house? Would it make any difference at all if indeed a matter comes up that you have to take by a vote? It wouldn't make any difference. It was only the previous parliament, that is the just ended parliament, where numbers such as that mattered so much because of the hand nature of parliament. In this particular case, I don't think that the presence or absence of one member from the minority side would have made any difference at all.
Do you agree with him when he says they achieved their aim?
Well, how do I know their aim? In order that I could say, okay, I could agree or disagree with it, I don't know what their aim was. So if honorable member for order and the minority side knew exactly what their aim was and the means by which they will achieve that aim and feel that that aim was achieved, I have nothing to say.
Thank you. Thank you very much for speaking to us.
You're welcome.
Well, taking us to 23 minutes past 8 here in the studios of Radio Gold 90.5 FM. We'll try and get somebody from the majority side to speak to on this issue. By the meantime, is